Kenny MacAskill.
Thank you, Mr Deputy Speaker. I believe that many of the ills that afflict Scotland can be laid at the door of this Tory government. One that hasn't been elected in Scotland, not for the 55 years of hurt experienced by English football fans, but for 65 years, longer than I've lived. Independence is therefore essential. But not all ills rest there, and some, along with their demons, such as alcohol and violence, can be and must be addressed by ourselves. The role of the Lord Advocate is one. The Lord Advocate and law officers, along with ministers, are part of Scotland's offices of state, enshrined in the Scotland Act 1998 that established the Scottish Parliament. It's why legislative change here is required. So I'm grateful for the opportunity to raise this, welcome the willingness of the UK Government to assist, and hope that urgency will now be shown by the Scottish Government. Scottish democracy badly requires it. Before the post of Secretary of State for Scotland was created, the Lord Advocate was the power in the land, and some were despotic indeed. The transportation of Thomas Muir and the hanging and beheading of Baird, Hardy and Wilson, the Scottish radicals and 1820 martyrs, are crimes that lie with them. Thankfully, the post evolved and became a purely legal role, but an anachronism was built in. For the post holder is both principal legal advisor to the Scottish Government, yet also head of the prosecution service, or the Crown Office as it's known. Now that's something neither replicated elsewhere in the United Kingdom, nor indeed in any modern democracy. Conflict of interest precluding it. In England and Wales, an Attorney General advises government from within. Meanwhile, a head of prosecution service is both separate and independent from government. But not so in Scotland, and therein lies the problem. To be fair, apart from those despotic years, post holders, irrespective of political hue, and whether pre or lies the problem. To be fair, apart from those despotic years, post holders, irrespective of political hue, and whether pre or under Alex Salmond's administration, a convention was invoked that the Lord Advocate only appeared at Cabinet when legal advice was to be given and didn't participate in wider political debate. But the anachronism still lingered. Under Nicola Sturgeon's administration, it has been brutally exposed by both Scottish Government and Crown Office actions, and with the Lord Advocate straddling both. Change is now needed, and fast. Firstly, there's been an admission by the outgoing Lord Advocate of malicious prosecutions involving the administrators in the Rangers FC liquidation. That's unprecedented in Scotland, not just in recent years, but since those days of the early 19th century. Even south of the border, there have been none since 1999, and high-profile cases before, such as Winston Silcott and Daniel Morgan, were rare. It has caused alarm with the public and been of huge reputational damage in an organisation where impartiality is imperative. It has also caused consternation and anger within police and prosecution services, where the overwhelming majority of staff act without bias and free of any favour or prejudice. The reputation of the many has been traduced by a few. It was the former Lord Advocate's decision, and seeking to cast blame on his predecessor was shameful and inadequate. An inquiry, perhaps even by a non-Scottish judicial figure, has been promised. Additionally, there's the financial cost. Quantum of damages is for the court, but suggestions are the final bill could reach £60 or £80 million. This in an organisation with an annual budget of £300 million, struggling to meet existing commitments. The price will be paid by Scottish taxpayers and the loss felt by hard-pressed Scottish public services. Secondly, and just as alarmingly has been the role of the Lord Advocate and a coterie around him within the Crown Office in the Alex Salmond case and the fallout from it. Another instance of the public having to pay the price of government incompetence, with the legal expenses bill in the civil case amounting to £500,000. But where again, impartiality as well as competence was raised. In the civil case, the presiding judge described the Scottish Government's actions as unlawful, unfair and tainted by apparent bias. During proceedings, Senior External Counsel Roddy Dunlop QC, Dean of the Faculty of Advocates, expressed horror at the situation he and his colleague had been put in by their client, where they could no longer rest on pleadings they knew to be untrue. The client was the government, and their senior legal advisor was the Lord Advocate. A criminal case followed the failed civil case and was prosecuted by the Crown Office, where the same Lord Advocate remained in office. Despite growing pressures on police and prosecution, nothing has been spared, nothing has been too trivial, but the targets always seem selective. The Alex Salmond case saw resources deployed normally reserved for a serious organised crime figure or a serial killer, yet for charges that, other than for who was being prosecuted, would either never have seen the light of day or only appeared in the lowest courts, not the High Court. I say that as someone who was Justice Secretary for 7.5 years, but was also a defence agent for 20. As it was, Mr Salmond was acquitted on all charges and by a majority female jury. Now, it's standard practice in cases involving politicians that the Lord Advocate recuses himself from involvement in the consideration or prosecution of a case. And that was done here, with no direct involvement in the prosecution. But at the same time, he had been and was sitting on Scottish Government committees dealing with the civil case and where referral or prosecution was being actively sought and advised by the administration. Let's recall, a prosecution was sought by the Scottish Government as the actions of the Director of HR in contacting the police confirm. Many complainers, indeed most, were and remain at the heart of government or are officials or otherwise closely linked with the governing party. Prosecution was encouraged and pressed for by the Chief Executive of the governing party and who's the First Minister's husband. Chinese walls and recusal are entirely inadequate. In one role, the Lord Advocate was supporting a government pursuing prosecution. In another, he was denying it was anything to do with supporting a government pursuing prosecution. In another, he was denying it was anything to do with him. A separation of powers. He was frankly evasive and obfuscating, mirroring the actions of the Crown and Government in a lack of openness and transparency. There was neither contrition nor candour. Open government this certainly was not. And the fallout and the failures continued to reverberate. Following on from Alex Salmond's case has been that of Craig Murray, a writer and a former diplomat. Now, his conviction's under appeal at the Supreme Court. Accordingly, I refrain from commenting on specifics of the case. Instead, I restrict my remarks to the decision by the Crown to prosecute Mr Murray for jigsaw identification of complainers in the case. But why was he prosecuted when others weren't? In one case, certainly overtly, and in many others, much more flagrantly than by Mr Murray, but no action was taken against them. Moreover, there were publications which in any other case would have constituted a clear contempt of court, but that went without censure by the Crown. They included newspaper articles that were as prejudicial as I've ever seen. But they were supporting prosecution, whereas Mr Murray, though seeking to report factually, wasn't. It does seem that the Crown has one law for those supporting the government line and another for those who challenge it. By all means.
I thank my honourable and learned friend for giving way. And I'd like to mention a case you'll be aware of journalist Mark Hurst, who was arrested and charged with threatening and abusive behaviour. However, when that case went before Sheriff Pasterson, he ruled that there was no case to answer, that Hurst had simply been giving his opinion of the situation within the SNP and no more than that. There are also cases of police knocking on doors for single tweets and others that are sub judice and where charges have yet to be brought. All of this is exerting a chilling effect on democracy in Scotland. And does he share my concern that even in the absence of any evidence of wrongdoing or malfeasance, any continued failure by the Scottish Government to address the separation of powers reinforces talk of deliberate and targeted harassment of individuals critical of the Scottish Government, its policies and its leadership, including its role in the Salmond affair?
Absolutely. Justice, there's a clear perception of there being far from equanimity or indeed even balance by the Crown. Now, James Wolfe has stepped down as Lord Advocate, replaced by Dorothy Bain. Miss Bain has an illustrious record of service and I wish her well. But the structural flaw remains. Personnel changes, no matter how merited, cannot resolve the fundamental flaw of a lack of separation of powers. The impartiality of the Crown's an imperative in a democracy. It must be seen to act in the public interest, not that of the government or its friends or allies. The coterie who surrounded Mr Wolfe and who were instrumental in driving these policies and actions, often against the wishes and views of long-serving staff, still remain. In particular, the Crown agent, Mr Harvey, the senior civil servant. Unusually, amongst senior Crown staff, his career hasn't simply been as a Procurator Fiscal in Scotland, but has included service and secondment to British government departments. The situation is now critical, as a police investigation has opened into the SNP's finances. The party leader is the First Minister. Her husband is Chief Executive. A situation, Mr Deputy Speaker, that would be intolerable in any public body or private company, or even in a bowling or social club in any Scottish town. The idea that the Chief Steward could be the spouse of the Treasurer would draw derision and rejection, but not so in Scotland's governing party. Worsening that furthers the fact that all three members of the SNP Finance and Audit Committee resigned from their roles when refused information by the Chief Executive. That, Mr Deputy Speaker, has been followed by the resignation of the elected Treasurer, the Honourable Member for Dunfermline, for similar reasons. Given what has happened, can the Scottish public be assured that the investigation will have access to all information, and that any decision to prosecute or not will be made on legal criteria and in the interests of justice? Protocols have failed, been breached, or even abused. Interim steps can be taken to separate the roles. Perhaps there should not just be a recusal, as there no doubt will be by the Lord Advocate, but as with the Rangers FC investigation, the bringing in of an external judicial advisor. Moreover, the Lord Advocate has recused herself from involvement in the Rangers FC civil proceedings. Maybe she could recuse herself from all direct government involvement. An in-house legal department exists. The duty to represent the government in court and pursue constitutional challenges remains, but that can be dealt with by external counsel. Change and a separation of powers there must be. The twin roles of the Lord Advocate in prosecution and in advising government are an historical anachronism, but entirely unsuited to a modern democracy. Government are an historical anachronism, but entirely unsuited to a modern democracy. As a former Justice Secretary and someone who's appalled at what has happened, and I know that's echoed in legal circles, by all means.
I'm very grateful to the Right Honourable Gentleman for giving way. I'm not going to comment on any of the particular cases he's mentioned, but what I'm going to say to him is he aware that the First Minister of Scotland has recognised that there's a case for reform here? And does he agree with me that all that's really needed is for this House to pass a bill to amend the Scotland Act to give the Scottish Parliament the power to make alterations to the role of Lord Advocate? And then the Scottish Parliament could properly consider what I think he's suggesting, separating it into roles akin to the Attorney General and the Director of Public Prosecutions in England. But I stress I'm not making any comment on the cases he's mentioned. I'm simply drawing to his attention the fact that the First Minister has recognised the case for reform and that this might be the best way to do it.
Well, I think recognition is one thing. Progress is quite another. We are now in July. Holyrood is in recess. We have had an election and we are still to see any action other than rhetoric from the Scottish Government. It's entirely inadequate. But I do accept what the member says, that it should be for the Scottish Parliament to decide what the structure should be. It has to be a structure, I think, that will mirror most democracies south of the border or indeed elsewhere, but it should be for the Scottish Parliament, but they have to show greater willingness. So I call upon the Minister to engage with the Scottish Government as a matter of urgency so that changes can be made to the 1998 Act. Changes providing for a complete separation of powers between the head of the prosecution service and the senior government legal adviser. Every modern democracy does so, and so must Scotland. The failures have been too many, and the risks are too great. For justice, Mr. Deputy Speaker, has not only to be done, but must be seen to be done. Thank you.
Hear, hear.
Minister.
Thank you very much, Mr. Deputy Speaker. And I thank the Honourable Member for East Lothian and congratulate him for calling this adjournment debate. I know that he and others, and he in particular, have taken a keen interest in this subject, and I'm grateful for this opportunity to hear his views and those of others on this important constitutional issue, particularly in light of his former role as Cabinet Secretary for Justice in the Scottish Government. I recognise the concerns that the Honourable Member has made during his speech, namely that of the dual role of the Lord Advocate, both current and historical. We always enjoy a bit of Scottish history when we hear the Honourable Member speak in this place. And that being a dual role of being a legal advisor, senior legal advisor, and the most senior law officer. The Honourable Member also referenced specific cases. I hope he understands it would be inappropriate for me or any minister to comment on those specifically at this point. And whilst the UK Government would have a role to play in any changes to the role of the Lord Advocate, I must stress that it would be inappropriate for me to speculate on what action should be taken at this time. I will therefore provide some context on the role of the Lord Advocate before I explain the set process any changes must go through before the UK Government can take a position. I'll give way.
For giving way. I hear that he's not going to speculate or set out a plan, but does he agree with me that one route might be for this Parliament to pass a bill amending the Scotland Act so that the dual role of the Lord Advocate could be revisited by the Scottish Parliament? Because, of course, under the current Scotland Act, the role of the Lord Advocate is reserved to this Parliament. So does he agree with me that one potential way forward would be to pass a very straightforward bill that gave the power to change the role to the Scottish Parliament?
I thank the Honourable and learned lady for her intervention, and I will be coming to that point in a bit more detail later in my response. And although that is possible in theory, what I'll explain later is why in practice the UK Government would choose not to go directly down that route. If the Honourable Member would forgive me, I'll come back to that in a minute or two. The context of the role of the Lord Advocate is the Scotland Act 1998, which I'll refer to for brevity as the 1998 Act. Section 48 of that Act makes provision about the appointment of the Lord Advocate and their removal from office. The 1998 Act itself came about after 74% of voters in the 1997 devolution referendum were in favour of a Scottish Parliament. The subsequent 98 Act devolved significant powers to Scotland, legislating for the establishment of a Scottish executive, later known as the Scottish Government, and a Parliament. The Scottish Parliament took responsibility in areas such as education, law enforcement, health and social care, local government, among others. But there are many others which remain the prerogative of the UK Parliament through Schedule 5 of the Act. There are too many of those to list, but a few examples would be foreign affairs, international trade, defence, national security, energy, and of course the Constitution. Since 1998, there have been two major adjustments to the devolution settlement, the Scotland Acts of 2012 and 2016. The 2012 Act represents the first transfer of fiscal powers from Westminster to the Scottish Parliament following devolution. After the independence referendum of 2014, where the clear majority voted to stay in the Union, and the Smith Commission, the 2016 Act was passed to transfer a range of tax and welfare powers to the Scottish Parliament. These acts have created one of the most powerful devolved parliaments in the world and give the Scottish Government power over numerous aspects of its governance. On the role of the Lord Advocate, which is reflected in the 1998 Act, as the Honourable Member will be aware, the Lord Advocate is the Scottish Government's most senior law officer and principal legal advisor, which is the topic of this debate. Section 48 of the 1998 Act, in addition to providing for the appointment of Lord Advocate and their removal from office, also makes provision about the independence of the Lord Advocate in her capacity as the head of the systems of criminal prosecution and investigation of deaths in Scotland. This is to ensure the traditional independence of the Lord Advocate in taking decisions related to those matters continued after they became a member of the Scottish Government. The Lord Advocate's role as head of the systems of criminal prosecution and investigation of deaths is protected in Section 29 of the 1998 Act from modification by an Act of the Scottish Parliament. Amending the Lord's In terms of amending the Lord's Advocate's role, the Honourable Member has referred to amending the role given the limitation on legislative competence in Section 29 of the 1998 Act. Any formal separation of the responsibilities would require legislation. And whilst the UK Government has the power to bring forward legislation to make this change, in practice we would want to ensure the Scottish Government have first put their proposals to the Scottish Parliament for scrutiny. I'll give way to the Honourable Gentleman.
But does the Minister not agree that there is distrust and conflicting opinions regarding the division of the role of the Lord Advocate within the Scottish Parliament and Holyrood, and these proposals would need to be scrutinised before the legislation of the Scotland Act is changed? And does he further agree that these matters must be addressed in Holyrood before Westminster is expected to change law?
I thank the Honourable Gentleman for his I thank the Honourable Gentleman for his very timely intervention, because that was kind of the point I was just making, which was, although the UK Government, as I responded to the Honourable Lady earlier, in practice we would want to ensure that the Scottish Government have put those proposals to the Scottish Parliament to be scrutinised in the Scottish Parliament. It's therefore a matter for the Scottish Government in the first instance. It's only right that the Scottish Parliament has an opportunity to scrutinise and debate these proposals. Only once these proposals were agreed in principle in the Scottish Parliament would we expect the Scottish Government to make a formal representation to the Secretary of State for Scotland as custodian of the devolution settlement, and then the UK Government would consider the next steps. As the Honourable Lady pointed out, or at least I think she was referring to, the SNP made a manifesto commitment ahead of the recent Scottish Parliament elections to consult on whether the dual functions should be separate in the future. It is right that our colleagues at Holyrood, rather than UK ministers, take the lead on deciding what must now happen, or at least take that first step. We have not received, as far as I know, at this time, any requests from the Scottish Government to amend the 1998 Act at this time, and it would therefore be premature for the UK Government to comment further on that point. I'll give way.
On that point, there's surely nothing to prevent the Scottish Government from returning to the informal arrangement of the Salmond Government, where the law officer did recuse himself from cabinet discussions in an informal basis, despite the separation of powers not being in place, and that would at least show some willing towards a formal separation or consideration of that matter before the Scottish Parliament.
Well, thank the honourable gentleman for his intervention, and of course what he's referring to is an informal arrangement, so by definition there would be nothing to stop that informal arrangement if that was agreed by those involved. But that's not, again, it's not for me as a government minister, a UK government minister, to decide upon that. In conclusion, Mr Deputy Speaker, the UK government continues to work closely with the Scottish Government on all amendments to the 1998 Act to ensure we are delivering together for Scotland. Devolution, brought about by the 1998 Act, is the means by which our two governments work together. The 1998 Act is also the means by which we continue to live in one of the most successful and long-lasting political unions in history as part of a devolution settlement that is aimed, and we strive at least, to strike the right balance. Thank you.
The question is that this House do now adjourn. As many as have that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. Order. Order.